Namaskar. I Adv.Juilee welcome you all in my YouTube channel. In the last week's video, I explained about the 5 myths regarding the will which we need to burst. And in that video, I concluded by saying that maybe next time making a video about essentials of the will be a good idea. That means if you decide to make a will, then what all need to be included in the will, what makes the good will. But then I thought, let's take a step back and explain about what factors one must consider while deciding whether to make a will or not. Many of my clients tell me that, Zuili, what? We know who all our family members are, and we know that after us, our family members will get the property. Then what is the need to make a will? Well, which is also fine. I understand this psychology, and it is okay whether to make a will or not is your personal decision. But what is important is that you must consider all the facts and take an informed decision. You must know about all the factual and legal provision, and then if you come to the conclusion that you don't need to make a will, that is perfectly fine. But it is very important to understand the provisions. So I thought, let me discuss about what factors one need to consider before deciding whether to make a will or not. So if you are also in a position where you're thinking, whether to make will or not, then this video will surely help you in making that informed decision. So please stay tuned till the end and let's get started. So why one makes a will? You know, why will is made? Because will creates artificial succession, which means what? You want to decide that after you, who should get your property in what share. If you want to dictate that, you make a will and you create artificial succession. But suppose if one person does not make a will, then what happens to his property? His property goes to his legal heirs as per the respective succession law. So when you make a will, you provide artificial succession, you dictate how you want your property to succeed. But if you don't make a will, then law fills this gap and law dictates who all your legal heirs are, and law dictates in what share they will get the property. Now this law is not same for all, it differs. Suppose if you are Hindu, Buddhist, Sikh or Jain, then Hindu Succession Act 1956 is applicable in case of intestate succession, that is when one dies without making a will. If you are Parsi or Christian, then Indian Succession Act 1925 is applicable in case of a person dying without making a will. If you are Muslim, then Mohammedan personal law will be applicable. So then the scenario is different for all. If a person makes a will, all provisions regarding the will and its probate are included in the Indian Succession Act 1925 for all, for Hindu, Buddhist, Sikh, Jain, Parsi, Christian. But the personal law is different for different people. So that is the first important thing which we need to understand. Now, suppose you are not making a will and you think that, okay, I know who all my legal heirs are. But the first important point is that whether do you really factually and legally know who your legal heirs are and in what proportion they will succeed to your property. First, be very sure about that. And let me explain you this with a practical example. Suppose you are a Hindu male and you die without making a will, then the Hindu Succession Act provides two types of legal heirs of a Hindu male, which are class 1 legal heir and class 2 legal heir as per the Hindu Succession Act. So class 1 legal heirs are the main legal heirs and they take the property primarily and they are being given priority. So if there are class 1 legal heirs, they will take all the property equally. Equally in the sense as per their share, not equally. There are nuances in that. And if there's class 1 legal heir, then class 2 legal heirs will not get anything. But suppose there is no class 1 legal heir available for the Hindu male, then class 2 legal heirs will take the property as per their share. Now for the Hindu male, who all are his class 1 legal heir? There is a long list given in the schedule in the Hindu Succession Act. So I plan to make a different dedicated video about that. But let's understand very easy scenario. In Hindu male's class 1 legal heir, there is his widow, his children, whoever, son's daughter, and his mother is also a class 1 legal heir. So suppose there's a Hindu male, who has widow, two children, and a mother, and he died without making a will. And suppose he has a flat in a Bombay in a cooperative housing society. So after his death, his flat 100% ownership will go equally to these four legal heirs. That is 25% each to his mother, widow, and suppose he has two children. Suppose there are three children, then 100% will be divided among five equally. So that is how the succession will take place. And many people don't know that the mother is also a class 1 legal heir, and she takes with the children and the widow if mother is alive when that Hindu male died, right? So that is very important. And why this is important practically, let me explain you. So suppose this a flat, this there is this flat, and 25% each to mother, widow, and two children. And now suppose that mother also died without making a will. Suppose that 25% of mother will go to whom now? To that mother's legal heirs as per the Hindu Succession Act, which will include that mother's other children, son and daughter. So can you imagine the 25% in this Hindu male's flat, which has gone to his mother, now will go to his brothers and sisters, real brothers and sister. And this is kind of a nightmare, because suppose the widow and the children of that original Hindu male want to sell that flat, they have to share the proceed with their uncles and aunts, okay, like bua and chachas, and they all need to sign the sale deed. Even if the flat needs to be given on rent, all need to be taken into consideration, and that is, very very difficult situation. And further that share will go to further legal heirs in intestacy. So that one thing which people don't understand, that this scenario can happen. Also, this is one scenario. In second scenario, suppose that Hindu male has predeceased son. Okay, so there are some living son and daughters, there is widow, mother, and there is predeceased son. Then that predeceased son's widow and children will also take his share. So can you imagine how many legal heirs will be there? So one flat suppose is there, it can have like 5 6 co-owners, and all need to be consulted and taken into consideration while selling that property or while renting that property. And this is very very crucial thing which we need to understand. And if you really want to restrict this shares getting diluted, then will is the way. So this is about the Hindu male class 1 legal heirs. Now sometimes people are under impression that particular person is a legal heir, but that person is not a legal heir. That has also happened in one of my case, in which there was this mother-in-law and daughter-in-law, the son predeceased, and the sasu. So that basically mother-in-law and the daughter-in-law, sasu soon, they were residing with each other. And that mother-in-law thought this daughter-in-law is my legal heir, so she is taking care of me, they had a good rapport, so she will be the legal heir and she will get the property. But no, as per the Hindu Succession Act, if there is a predeceased son and there's mother-in-law, then that predeceased son's widow is not this mother-in-law's legal heir. Okay, this is very important thing we need to understand. So there were just these two ladies, there were no children even to that daughter-in-law, so they were just living two ladies, and they're not each other's legal heirs under the Hindu Succession Act. But in this scenario, that mother-in-law made a will, gave her property to the daughter-in-law, so that daughter-in-law was, protected. Otherwise, she would not have been, gotten anything in her mother-in-law's property, because she's a widow of a predeceased son and she's not a legal heir of the mother-in-law. So this is also very important, which we need to understand, that who all are the legal heirs, who are not the legal heirs. And this is I'm explaining just about the Hindus. For the Christians and Parsis, the intestacy provisions are all more complicated under the Indian Succession Act. For Mohammedans also, it is very, very complicated. So if you're deciding that you don't want to make a will, fine. First, understand which personal law is applicable to you, who all are your legal heirs, and in what proportion they will get the share. And if you're perfectly fine with that distribution after your death, fine, you can take an informed decision that I don't want to make a will. But if that is not the situation and you want to really control that and create a succession, then you have to make a will. So this is first foremost very important point which we need to consider. So in the first point, I explained that if you want to decide whether to make a will or not, understand about the legal heirs. Who are the legal heirs and what share they will get. But suppose you want to make a will, sorry, you want to give a property to somebody who is not your legal heir under the law, as I explained about the mother-in-law and daughter-in-law. Or suppose you want to give some share in your property to some distant relative who is not your legal heir. Or sometimes I have seen, various my clients whose children are NRIs and they are living abroad. So even their house help or there's some relative in India is taking their care. So they really want to provide some part of their estate to such people who are not their legal heir. Sometimes they're not even relatives, they are some distant person but who are really important. So how you can do this? You can do such distribution only by way of making a will. And also important thing is about the share of the property. So suppose there is this Hindu husband, he knows that his wife is there, but his wife will take a property equally with the children. But what if you want to give more property to your wife? Suppose you want to give entire property to the wife till she's alive. So you want to create a life interest. Or suppose you don't want to give her full property, but 50% should go to the wife and 50% to the children. That provision you want to make. So law doesn't provide about 50% to the wife and 50% to children. Law provides equally to all class 1 legal heirs. So in such cases, the will is only the way. So the second point you have to consider is, if you want to give property to somebody who is not your legal heir, or you want to change the share of the property of your legal heirs, then you must make a will and make those provisions. So this is important point. Now third important point to be considered to decide whether to make a will or not is the position about the joint ownership and nomination. Many people have this misunderstanding that if there is a joint ownership, then the survivor owner will take the whole property. And this is mainly happens with the husband and wife, where people think that husband is a 50% owner, wife is a 50% owner. So after the death of anyone, the survivor will take whole, which is not true. This is not like a bank account where there are either or survivor operational instructions. In the immovable properties mainly, this is not applicable that survivor will take the whole. So suppose there's a husband and wife, 50-50% each, and suppose they're Hindu, then if husband dies, then his 50% share will go to his class 1 heirs, as I explained earlier. So his 50% share will go to either his mother if she's surviving, him, his widow and children equally, and the 50% is with the wife, that will be intact. So this is the important thing which needs to be considered. And the second most prevalent misconception is about the nominee. Now with the changes in law, awareness is coming, but still there is this misconception where people think, okay, I have made my son a nominee, so he will get the flat when, after my death, which is not true. The law is clearly laid down that nominee is just a trustee. He's like a trustee of your flat till the legal heads obtain proper probate or letters of administration from the court, or there's proper family arrangement between the legal heirs. Till then, that nominee is just a provisional member of the cooperative housing society, and the nominee is not the owner. So if you have a misconception that okay, there is a joint ownership or there is a nomination in my flat, so I don't need to make a will for that, then that is absolutely not true, and you need to revisit your decision. Now, the fourth important point about deciding is that in will you can give clear instruction to your legal heirs about certain points which you want them to do after your death. So, for example, if you believe in certain cause and you want to make provision for the say annual donation to particular NGO, you can do that only by making a will. You can give clear instruction to your legal heirs. So, your legal heirs who are going to take benefit of your property, they also have to make sure that they do that donation, or they fulfill your that wish. Because when the legal heirs go to the court, to the will, or to the probate or letters of administration in Bombay, the officer of the court clearly asks for the proof that this is the wish of the deceased person regarding the donation, so have you fulfilled that? Then please provide us some proof about these donations. So you can be sure that, rest assured that your instructions will be fulfilled by your legal heirs when you are not there. So suppose if you want to give instruction about donation of your skin, organ donation, eyes, etc., then that also you can do through will, and they will, your legal heads will have to honor those instructions, submit the proof to the court when asked for. So and suppose if you have already made some provision about your organ donations something, then you can give those details to your legal heirs in your will. And also suppose you want to give any instructions regarding whether to perform any rituals or ceremonies after your death, or to give information in the newspaper, or to hold a prayer meet. Because some of my clients, give such instructions in the will about what they really want their legal heirs to do. So will is an excellent way in which you can lay down all these clear instructions, and the court will also make your legal heirs accountable for those instructions, and you can be sure that those instructions will be fulfilled. So this is one important point regarding the will. And the last and but not the least important point is regarding your assets. Because see, your legal heirs are going to inherit those assets, and many a times the legal heirs don't know which are the assets of the deceased person. So in the will you can give the clear list of all the assets, so your legal heirs don't have to run here and there and try to gather information about what all are the assets, and they know clearly, okay, these are the assets, which we need to basically take benefit or give donations or whatever we need to do. So that you can do. But here also I want to give one practical explanation, is that many people don't prefer to disclose everything in the will about all details about their investments or bank accounts, everything in the will. But many people prefer to make a separate excel sheet and let their legal heirs know that these are the properties basically, and not make disclose everything in the will, which is also fine, which you can do if you're not comfortable that you don't want to make a detailed will. That is also doable, but make sure that you make a document in which you explain this everything and let your legal heirs know that these are my properties which I need you to take care of when I'm not there. Because in one particular case of mine, my client who was a US citizen, he came to India, and he was the only legal heir of his uncle and aunt, that is his father's brother and wife. Basically he was the only legal heir, and he didn't know about what all properties they have, and he wanted to make representation in the high court to get letters of administration. So he really had to run to this bank, that bank, this mutual fund depository participant, to get all the information about FDs, various bank accounts, because there was good amount of property, around a crore rupee of a property in different asset classes. And he was saying, this is costing me so much, coming from the US every 6 months and trying to gather all the information. It was really taxing for him, but he wanted to do that because otherwise that money would be just wasted. So he wanted to make sure that he collect all that money and he uses it for the good causes. But he really had to do all these efforts of collecting the information. So in the will you can give all this information, or at least have a separate excel sheet explaining all your properties, and that is really required. Okay, so that's it for the today's video. These are the 5 important points which you need to consider to decide whether to make a will or not to make a will. So please understand this thoroughly and study all these points, and then take informed decision that okay, I want to make a will, then go about it. Or if you decide no, I don't want to make a will, then that's fine too, but take informed decision. And in the next video, suppose after this video you decide that yes, you want to make a will, it is a good thing and important thing for you to make your will, then in the next video we will discuss about what are the legal requirements and some of the practical tips about how you should make a will, so as to make things easier for your next generation. So this is it about today's video. If you really found video to be informative, then please like it, share it with others, and subscribe to my channel. I've also written blog about this topic about making the will and points to be considered, which is available on my website adv.Juilee.com. I will give the link in the description, so do check out that blog and leave your comments there also. And that's it. Take care. I'll see you in the next video.